Imagine a scenario where the president wants to deploy the National Guard to a state, but the state's government vehemently opposes it. This very situation unfolded in Illinois, leading to a legal battle that went all the way to a federal appeals court. The core question: does the president have the power to deploy the National Guard against a state's wishes, even without clear evidence of a full-blown rebellion? A federal appeals court panel has sided with the state of Illinois, refusing to lift a lower court's order that blocks the Trump administration from deploying National Guard troops within the state. This decision underscores a fundamental tension between federal and state power, a cornerstone of the U.S. Constitution. The three-judge panel on the Seventh Circuit Court of Appeals stated that the Trump administration's attempt to deploy the National Guard troops was a likely violation of the 10th Amendment. For those unfamiliar, the 10th Amendment essentially says that powers not specifically given to the federal government, nor withheld from the states, are reserved to those respective states or the people. In simpler terms, it's about keeping a balance of power between Washington, D.C. and the individual states. The court also found that the Trump administration was unlikely to succeed in proving that a genuine rebellion against the authority of the U.S. government existed in Illinois. To deploy federal troops, the president typically needs to demonstrate that regular federal forces are unable to enforce federal laws. But here's where it gets controversial. What exactly constitutes a rebellion? Is it simply widespread protests, or does it require something more, like armed insurrection against the government? The panel's decision effectively maintains the status quo in Illinois, preventing the federal government from deploying federalized guardsmen anywhere within the state for now. This temporary restraining order remains in effect until at least October 23rd. A U.S. district judge has scheduled a hearing for October 22nd to decide whether to extend the order further. This legal back and forth highlights the checks and balances built into the American system of government. As of last week, approximately 200 federalized National Guard troops from Texas and 14 from California were already present in Illinois. Additionally, about 300 guardsmen from Illinois itself have been mobilized by the president. And this is the part most people miss. This mobilization happened over the objections of Illinois Governor J.B. Pritzker, highlighting the deep disagreement between the state and federal governments on this issue. President Trump had previously stated that the Guard troops were needed to address crime in Chicago, which he famously described as a war zone. He also argued that they were needed to protect federal immigration facilities, which had been the site of clashes between protesters and federal immigration agents during stepped-up immigration enforcement efforts. Some might argue that the president was genuinely concerned about public safety, while others might view this as an overreach of federal power. However, the appeals court panel found scant evidence that the protests in Chicago amounted to a rebellion. Political opposition is not rebellion, the judges wrote emphatically in their decision. They further clarified that even spirited, sustained, and occasionally violent actions of demonstrators in protest of the federal government's immigration policies and actions, without more, does not give rise to a danger of rebellion against the government's authority. Similarly, the judges concluded that there was insufficient evidence that protest activity in Illinois has significantly impeded the ability of federal officers to execute federal immigration laws. While an immigration facility in the Broadview suburb of Chicago had experienced regular protests, it remained open, and the protests were quickly contained by local, state, and federal authorities. Furthermore, the court noted that immigration arrests and deportations have proceeded apace in Illinois over the past year, and the administration has been proclaiming the success of its current efforts to enforce immigration laws in the Chicago area. Therefore, the court reasoned, the administration was unlikely to succeed on this argument. This case raises crucial questions about the balance of power between the federal government and the states. When, if ever, is it appropriate for the federal government to deploy the National Guard within a state against the state's wishes? What level of unrest or opposition constitutes a rebellion that justifies such action? And ultimately, who gets to decide? Is it the president, the courts, or the states themselves? What do you think? Feel free to share your perspective in the comments below.